That's perfect. All right. Good afternoon, everyone. I am attorney Sasha Watson. I'm an immigration attorney with HAWM Law. We are locally based out of Orlando, Florida, and one of our primary practice areas is immigration law, in addition to criminal defense and family law. Um, I've been doing this for 18 years. Our firm is 15 years old this year. We're fairly well established boutique firm servicing the needs of Central Florida families. And so we do understand that the this informational session is really important right now because there's so much anxiety and uncertainty around foreign travel. I'm a foreign traveler myself. I enjoy it as my pastime. So I do understand the anxiety and I've experienced it myself, especially under this new administration and the various changes that they have been implementing. So I'm going to go through and kind of address the questions that was posed by some of the travelers and try to discuss it as best as I can. And feel free if you have questions. I'm looking at several different screens. So Sabri, you can just let me know if anyone raises their hands and have questions. I think interactive presentations sometimes are more beneficial in answering questions that people may have as opposed to me just talking ad nauseum, which I can do because I am an attorney and that's the occupational hazard.
Thank you. I will.
Yeah, so these are topics that we intend to cover today, the risk factors. One of the common issues that we see with international travelers coming into the United States is unlawful presence, the impact that that could have on your status, paying attention to your travel history, what to do at border security checkpoints, and coming through Customs and Border Protection more so than TSA, essential documents that you need, advance parole and travel for, or non-US citizens traveling, or non-green card holders traveling, and just general legal advice. Okay. All right. So for risk factors in terms of what are the specific risks associated with my visa or green card status when traveling internationally. Okay, so let's start at the at the very top. U.S. citizens cannot be refused admission into the United States. So if you are traveling on a United States passport, you will go through primary inspection where your documents may be checked, but you cannot be refused entry into the United States for immigration purposes as a citizen of the United States. Then we have our green card holders. Green card holders are citizens of other countries who have been granted the permanent right to live and work in the United States. And generally speaking, green card holders who are traveling on short, casual, and innocent vacations or trips that are of short nature, meaning they're less than 6 months, they're not considered to be seeking admission under the immigration laws and therefore must be admitted back into the country, similar to a US citizen. So, as long as a green card holder has not been outside the country for more than 6 months, they're generally not seeking admission. That is also true if they don't have any criminal issues. If they have criminal history, then they could be considered to be seeking admission, for which Customs and Border Protection will review their criminal history, determine if they're seeking admission, and then make an assessment on whether to admit them into the United States, right? In those cases, certain crimes will make you inadmissible and will mean that these green card holders are seeking admission. And it's a really, really technical issue under the law that I don't want to overwhelm our viewers on the technicality of it. But for example, if you've been convicted of certain drug convictions, if you have certain fraud convictions that qualify as a crime involving moral turpitude, you could be considered to be seeking admission, and therefore Customs and Border Protection will have the right to deny you admission. That does not mean that they will return you from the country that you're coming from or that they will return you to your home country. When they deny you admission as a green card holder, they have to place you in removal proceedings for deportation, and you have the opportunity to go before an immigration judge with your case. The only person that can terminate the status of a green card holder is ultimately an immigration judge. But Customs and Border Protection, in their primary or secondary inspection, will make that assessment on whether your case needs to be referred to a judge for further proceedings as to your admissibility. Okay? So that's what happens there. If you are a green card holder and you've traveled for more than 6 months, meaning you've been outside the country for more than 6 months, you are going to be considered seeking admission. And they're going to look at your travel pattern to say, have you been living really more outside of the United States than inside the United States? And therefore, the green card is not being used for the purpose that it was intended. And that's when they start to talk about possibly issues of abandonment. Realistically, under the law, a green card holder does not abandon their residence until they've been outside the country for more than a year. Then our other categories of travelers are people who we consider are non-immigrant visa holders. These are people on tourist visas, student visas, work visas that are only here in the United States for a temporary period of time, right? It's a limited purpose, and it is a purpose tied to the type of visa that you have. These individuals are always considered to be seeking admission, not because you hold a visa means that you are going to be guaranteed entry into the United States. The granting of a visa really only permits you to board an international carrier and to travel to the port of entry in the United States. When you come to the United States and you present yourself for inspection with Customs and Border Protection, that is when they will make an admission decision. And for non-immigrant holders, that is always the case. So if you have violated your visa in any way, meaning, for example, you are a student and you've worked without authorization, and Customs and Border Protection suspects that has happened, or they have proof that it's happened, they can deny you admission and return you to your home country. Okay? Then we have people who are in a transition, meaning that they're going from possibly a visa status, a non-immigrant visa status, to a green card holder, and they're traveling on what's called advance parole. Those individuals who are traveling on advance parole are also seeking admission into the United States, but they have been granted advance approval to come into the United States. And in those cases, Customs and Border Protection, again, will make an assessment, but they will ultimately let you in. If there is a problem, they could put you in removal proceedings as a result. Okay? Anyone has any questions about this? No? Okay. U.S. citizens do not accrue unlawful presence. You're here, you're living in the country of which you are, you are a citizen. Same thing with green card holders. You have the unrestricted right to live in the United States. When we talk about unlawful presence, and the question that was posed was, how do I accumulate unlawful presence and how could it affect me, right? If you are here on a non-immigrant visa, that non-immigrant visa, whether it's a student visa, a tourist visa, a H-1B, L visa, or some other work-related type of visa, your entry into the United States is typically limited, right? For the student visa holders, we consider them to be what we call duration of status. So as long as they're maintaining their status, they're attending school, they're not violating their status, they can remain in the United States indefinitely. They will not accrue unlawful presence until they have a status violation and there is a finding by an immigration official. If you are on a tourist visa, you will have a visa in your passport, which is really should be considered permission to travel. That visa may be valid for 10 years. In some cases, you may have, people have different types of visas that are valid for 5 years or 3 years. That just says, hey, you are permitted to travel to the United States for an unlimited period of time, amounts of times during that 5 year period. However, when you come to Customs and Border Protection Patrol, they are going to, CBP is going to authorize you to be in the United States for a certain limited period of time. Usually for our tourists, that's 6 months. It can be less than 6 months, but on average, most people get 6 months stay. And that's regardless of whether you have a 10-year or a 5-year visa. Your permission to be in the United States could be limited by your what's called your I-94 admission record. Once your time on your I-94 expires, you begin to accrue unlawful presence. So every day that you are in the United States out of status, you are accruing unlawful presence. Unlawful presence can trigger an unlawful presence bar. There is a 3-year bar for individuals who have overstayed their time by 180 days. So for the first 180 days that you're here unlawfully, there is no bar. But once you get to 180 days and above, you now have a 3-year bar. If you get to 1 year, you have a 10-year bar on re-entry. So that unlawful present bar is triggered once you depart the United States. So if you've been here in the United States for 9 months, unlawfully, meaning you, for example, a tourist, they come in January, they have until June 30th to be here in the United States, and they decide they're not going to leave, and they stay till the following year of March, for example. They've accrued roughly 9 months of unlawful stay, and when they depart, they will trigger the unlawful presence bar for 3 years. Once you overstay your visa, right? From the day you overstay, it is an automatic cancellation of the visa. Even if you haven't gotten to the unlawful presence bar. So if you've overstayed by a day or 3 days and you have not filed any applications to extend your time in the United States, you would have triggered the automatic cancellation of visa provision under the INA. It's also important to know that unlawful presence only accrues for individuals who are over the age of 18. So if you've brought a child into the United States, they've overstayed their time, they're not going to accrue unlawful presence until they turn 18, which is important because if they intend to change their status later on to a permanent status, it may be necessary to know the fact that they have not accrued unlawful presence while under 18. You want to avoid accruing unlawful presence. You want to, especially in this climate, you want to comply with your visa. And if you're not sure, if your thought process is, hey, I want to remain in the US because I'm going to apply for some immigration benefit or that will change my status from a non-immigrant visa possibly to a green card holder, it's important that you evaluate your options with an immigration attorney, because there are certain individuals who, even if you've overstayed, you're not going to be eligible to adjust. depending on the category of visa or immigrant visa that you may apply for. So prior to overstaying, you want to really assess your immigration situation and have a discussion with a competent immigration attorney to determine what are the real penalties that will be applicable to my individual case. Could my international travel impact my current immigration status or any pending applications for adjustment of status? Yes, absolutely. If you are in the United States and you are applying to adjust your status from some type of non-immigrant status to that of a green card holder, which is an immigrant status, while that application is pending, you are landlocked in the United States. If you travel, your application is deemed abandoned unless you have obtained prior travel authorization from USCIS. So if you travel without the travel authorization, your application would be deemed abandoned and you would not be able to return to the United States. And most likely will have to process your application at a consular post outside the United States. Travel can also, even though this was not in the question posed, it can also have impacts on your eligibility for citizenship. In order to obtain US citizenship through the process of naturalization, there are some physical presence requirements and continuous presence requirements, right? So one of the requirements is that you have been continuously present in the United States, meaning that usually there's a 5-year statutory period or a 3-year. Half of that time has to be in the United States. If you are outside the United States for more than 6 months, it is that 6-month travel cuts off your continuous presence and makes you ineligible for citizenship. You must be physically present within the United States at least half of the statutory time in order to be eligible for the citizenship through naturalization. Should I be concerned about my travel history or previous immigration issues when re-entering the United States? Yes, it's possible, if you are going to fall into the category of seeking admission, and CBP will be assessing whether to admit you into the United States, you should be concerned about your prior travel history as well as your immigration history. This issue comes up quite frequently with individuals who travel a lot or spend quite a significant amount of their time in the United States. Meaning, if you have a tourist visa and that tourist visa grants you, when you come in, you get 6 months each time you visit. So you spend 6 months and then you go home for 2 weeks and you come back for another 6 months. Now you're living in the United States. And if that is a consistent pattern, they're going to say you are not using the tourist visa for the purpose for which it was intended, right? The tourist visa is for recreational travel, meaning you're coming to shop, you're coming to go to the parks, you're coming for a short period of time to visit relatives in general. Or you may be coming in for business tourism, meaning you're coming in for a conference or you're coming in to possibly engage contractors for your business or to handle business dealings, not to work, but to establish business relationships. You can do that on your tourist visa. But if you are spending most of the year in the United States, it will raise red flags as to whether what your conduct and your travel patterns is in violation of, for example, a tourist visa, right? Same thing if you are working. They're going, the suspicion of work in violation of your status increases if you spend in the aggregate 8 months out of the year in the United States and you're only back in your home country 2 months. Each time you do that, you are increasing the risk that your tourist visa will be canceled, right? So you want to be mindful of that. So other things that CBP will consider when you're evaluating inadmissibility or admissibility is that they can look at your social media as well. We've heard a lot of talk and discussion about that, about social media vetting. You know, right now we have an administration that is very concerned about people's um, ideologies and what they put out on social media. Does it align with their policies on what is important in America? And that can become problematic when you're traveling into the United States. So, and I think it may be on a later slide, but I will discuss it a little bit, is that when you travel into the United States, and this applies across the board to everyone, even to US citizens, green card holders, and foreign nationals on tourist visas or other types of non-immigrant visas, you are subject to warrantless searches and seizures. That is what gives them the authority to search your bag at the airport. We've all had it happen. You know, if you traveled enough, your bag may have been searched once or twice, right? Um, and that is perfectly normal. They don't need a search warrant to search your bags when you're coming through the airport. They don't have to have suspicion because under our laws, the at the border, it is warrantless searches. And that also includes your electronic devices, laptops, computers, your cell phones. They are subject to search, just like your back. And that is how they can look on there, determine, did you have a conversation with such and such person about working when you're coming into the United States? These conversations seem suspicious. They look at your Facebook page or your Instagram or your TikTok to assess, are you a threat to the United States? Are you a threat to national security? Are you engaging in terroristic activity? And now, unfortunately, are you espousing ideologies that are not consistent with US principles and values, is how they word it, right? So these are all things that can come up and present red flags when you travel, in addition to your travel history. And this is what I mentioned. What should I expect during the re-entry process, especially regarding border security checks? So CBP has the authority to conduct warrantless searches at the border, each port of entry, and up to 100 miles in the interior. That means in certain parts of the United States, like the state of Florida, CBP has the ability to do warrantless searches anywhere because everywhere within the state of Florida is within 100 miles of the border. And so that means persons, bags, electronic devices can be searched by CBP officials, right? And we see that at airports. We expect it to happen when it happens to our person, you know, where they can conduct body searches. They can do searches of all your bags and items on you. And, you know, and that's for any CBP purpose, right? And like I mentioned earlier, the electronic devices. When you do enter, there is a primary inspection, which typically includes looking at your passport, scanning your passport for biometric data into the national system to make sure there are no warrants out for your arrest or anything like that. Um, they will do a review of your visa, and that's typically very brief. It's not, it, you know, we're saying these are all the things that are happening, and CBP takes a position that that's what they're doing. But a lot of these searches can be done, and these reviews can be done within 5 minutes, right? So these are quick searches. If something does come up, or you are red flagged for a particular reason, for example, you may have some criminal issue or history or arrest or conviction in the past, and you're going to get sent to secondary inspection. Secondary inspection can happen even for US citizens, right? Because they're flagging you for criminal issues as well as national security risk, and so far. So it's not limited to people who are non-US citizens. This can happen as well. Generally with these searches, for me, when I advise my clients is to just be calm and to be confident, right? In Because I think CBP, for lack of a better phrase, I would say they're like dogs. They can smell fear, and your fear raises suspicion, right? So you want to be confident of why you are coming to United States. When you go to the border and you tell them, "Hey, I'm coming in to visit for this purpose," or "I'm returning home from this trip," it needs to make sense. If it doesn't make sense, you're going to raise red flags and you're going to end up having some secondary searches or investigation into whatever it is. And this can happen for US citizens, right? Because remember, like I said, it's not just immigration violations. They're investigating, or they're doing these searches and questionings at the border to also stop human trafficking, drug trafficking, things like that. So we're all subject to these questions, and we're all going to be asked, where did we go? What did we go there for? Who did we go with? And if you know, raise red flags, which they are trained to spot, you could be subjected to secondary search, especially if you, and then CBP is a big component of the work they do, right? Immigration is really a small component of the work that CBP does. One of the major parts is preventing contraband, agricultural contraband from coming into the country that could pose significant health risk, or economic risk for or livestock and crops and so forth. So when you travel outside and you're bringing back food, you're automatically going to be red flag for that as well. So you want to be aware of that. So the question is, what specific documents should I carry to ensure a smooth reentry and avoid any deportation concerns? US citizens need to travel with their passport. If they're traveling through a land or sea port entry, for example, on a cruise, you don't have to have a passport, but you can use a passport card. Green card holders need to have, and as well as non-immigrant visa holders, they need to have their passports with the visa in them, or add along with their green cards if they are green card holders. I recommend individuals who are US citizens to apply for global entry, because it smooths your entry process into the United States. And if you travel frequently, global entry basically pre-vets you. And once you're on the list, you are now considered a safe and trusted traveler. So you will find that you will have less friction upon entry as a global entry traveler, right? If you are going through immigration processes, you're applying, you have pending applications. My recommendation during this current time is to limit travel to essential travel. And when I say essential, I mean life or death. If you have to travel to get medical treatment, to care for a sick and dying loved one, those are essential travel, right? And when you do that, you want to make sure you have all the pertinent information regarding your immigration case. Any receipt notices that you've received, all the, your application receipt notices, making sure that they are valid and current, all your documents for any travelers. You want to make sure that your travel documents are valid and that that validity will cover your return into the United States. Okay. Uh, If I have applied for the adjustment of status, do I need to obtain advance parole before traveling and what? Yes, I have answered this question. You absolutely need advance parole before traveling if you are applying for adjustment of status. If you travel without it, your adjustment application is going to be automatically considered denied, or abandoned, and it will ultimately be denied. So you cannot travel outside. You're landlocked until you have that advance parole document in order to travel outside while you have a pending application. I will reiterate that there are risks with traveling on advanced parole. Um, when when it comes to immigration laws, we have two subsets of laws. One is for admission for people coming into the United States, and one applies to deportation, people we want to kick out of the country. The laws granting you admission are much harsher and usually much stricter than the ones to kick you out. So once you've traveled and you come back seeking admission, you're going to be subject to sometimes harsher laws, right? And one of the examples of that is, for example, if you're here and you've been arrested for, let's say, a marijuana offense, a simple personal use marijuana offense, you're generally not deportable for a single offense of possession of marijuana, less than 30 grams. But if you travel and you go on vacation and you try to return, you are absolutely inadmissible for that same offense. So although you could not be deported for it, you will likely be refused entry or placed in deportation upon travel back to the United States. And there are several different types of offenses that could trigger inadmissibility and subject you to that. Also, when you travel on advanced parole, when you come back, you're not admitted, right? You are seeking admission, and that law will continue to follow you until you are approved for whatever application or benefit you have applied for. Should I consult with you or another immigration lawyer before making travel plans? And if so, how far in advance? Okay. The vast majority of people who will travel internationally do not need to consult with an immigration attorney prior to travel, right? If you are a US citizen, you have a US passport, you have a US birth certificate, you have a naturalization certificate, you have a consular report of birth abroad, you do not need to consult with an immigration attorney prior to travel. You can travel freely and you must be allowed admission back into the United States. If you are a green card holder, you've never been arrested, right? Your green card is valid. You don't have any criminal issues. You can travel. Okay, and mind you that you're not in any deportation, pending deportation proceedings either. You are fine to travel. If you have pending immigration applications, if you possibly suspect you could be in removal or deportation proceedings, meaning you have, you've applied for a benefit, it was denied, and nothing's happened, and you're still waiting, you need to do that. You need to see an attorney first. If you have a criminal history, you've been arrested or convicted, you need to consult with an attorney before you travel, right? This is for our non-US citizen, or this does not apply to the US citizens, but green card holders. If you've been arrested or convicted of a crime, you need to consult an attorney before travel because your travel could result in you being placed in deportation proceedings. Okay. You want to be aware of the risk prior to travel. And ideally, you want to have that consultation probably 4 to 6 weeks before your intending travel to allow sufficient time for the attorney to assess your history and possibly give you an opinion depending on how in-depth your immigration history is. Emergency situations. If I face a situation abroad and cannot return to the US without legal options, what legal options do I have to resolve my status? If you have an emergency situation abroad and you're a US citizen or even a green card holder, you want to consult the US embassy or consulate for assistance. Most US embassies also have a pre-travel safety mechanisms where you can send the US embassy your travel information. So they have a copy of your passport and so forth. So that embassy in that local jurisdiction is aware that you're present in the country and they're aware of your travel history before you leave the country. And if you are a solo traveler, that is probably something that you should do as a matter of prudence, just in case something happens to you, whether it's intentional or accidental, so that the US Embassy or consulate, wherever you are traveling to, is aware that you're there, right? Um, you also, emergency situations, keep copies, electronic copies of your important travel documents, your passport, your green card, any USCIS notices, your advance parole document. You want to have copies of those electronically stored just in case they get lost, right? Because having that copy could speed the process of getting them replaced, okay? If you are outside the United States and you're stuck, I see here we talk about the returning resident visa, meaning these are for green card holders who've been outside the country for more than a year and who have been deemed to abandon your residence. You can apply for an SB1, which is a returning resident visa, and explain to the US Embassy why you were outside this long, what caused the extended departure from the country, and how you still maintained your residence, and you will get an SB1 visa to return to the United States, right? Um, and that's typically what we look into. If you lost your passport, if you lost your green card, the embassies usually generally have emergency divisions that will facilitate replacement of those documents, or at the very least, to be able to grant you what's called a boarding foil that will allow you to board an international carrier and travel back to the United States, where when you return, you can apply for whatever replacement documents that you may need. If you have a prior deportation or removal order, you definitely should not be traveling without legal advice, right? If that removal or deportation order has not been rescinded and your proceedings have not been terminated, you just need to get with a competent attorney to discuss your specific case, because there are so many different possible scenarios that it would be hard to go into details about that, because really with immigration, every case is unique. There are always twists and turns to the cases, and especially cases that where people have removal orders. You want to make sure that you've evaluated your case, determine how to fix your legal status prior to traveling to the United States, outside of the United States. Okay. Any questions and or answers? There's a question and answer segment. So if you have any questions, let me know.
Well, I definitely know
If
this
you
cleared
lost
up. Oh, go ahead.
if you lost your green card, and where now you at the driver's you lost your wallet and you have no driver's license, no social security card, and you lost your green card. And basically now when you go to the driver's license place, they ask you for a green card. So now it's taken about almost 4 to 5 months to get a green card.
So when you say portable, have you already applied to replace the green card?
No.
Okay. So that's what you need to do. You're in a situation where the green card is lost. You typically are going to need it. With the new Real ID Act, which is now in full effect as of May 7th, in order to get a state ID, a real ID Act compliant ID, you have to prove that you have lawful immigration status in the United States. So that means that the first thing that you're going to need to do is to apply to USCIS to replace your green card. Once you submit that application, you can call the 800 number and get an appointment to have a temporary green card stamp placed in your passport. And that temporary green card stamp is usually valid for a year. And that's what you can use to get your license until your green card is replaced. The replacement of green cards is what I call a non-adjudicatory process. It's akin to replacing your driver's license, meaning that when it doesn't matter what your criminal history is, you just submit your application, your green card will be replaced, right? There's no one assessing whether you should get the green card back or whether you're out of status. The fact that you have an expired green card doesn't mean you've lost your status, right? All that needs to happen is you need to replace that card. And there is usually zero risk. There's zero risk with green card replacements. So there's no reason that anyone should not have a valid green card if you are a green card holder.
Thank you.
You're welcome.
Oh, that was wonderful. Thank you for that question. Thank you for clarifying up any confusion that I had. Does anyone else have any questions?
No?
I have a question again.
Go ahead.
The reason I have a question is I have other people that I'm dealing with that have some immigration issues, but they more Spanish. So one of the questions I have, if you are in a proceeding removal, and now you lost your green card, but you're in a proceeding removal, but you're not completely, they haven't removed because you have to a date you have to actually gotta go to
Court.
So now you want to replace your green card. Can you do that?
You won't be able to replace the green card while proceedings are pending, but you are entitled to that temporary stamp. So you would still do the same process that I articulated before. You're going to call the 800 number, tell them you need to get a temporary proof of your green card status, because the only person who can take that status away is that immigration judge. So until the judge enters an order stating that you're removed, you remain a green card holder and you're entitled to that, what we call ADIT stamp, ADIT stamp, as proof that you are authorized to live and work in the United States.
But you cannot travel with that temporarily. Would you be able to travel?
You can. Individuals who have the temporary stamp can travel, but that's a split question. If you're in removal proceedings, I do not recommend that you travel.
Okay.
Okay. If there are no further questions, I'll tell you, we practice immigration law. We're based out of downtown Orlando. We service immigration clients nationwide. The best way to reach our office is 407-802-3223. Our HAWM, having an attorney when it matters.
Thank you so much. I was going to ask for your your information. I appreciate it. So I guess we're clear. Does anyone else have? Thank you. There we are.